and you are tuning in to the all-new Nooga Radio, all-new Nooga Radio here in Chattanooga, 92.7 FM and 95.3 HD4. That's digital. And we want to ask a question about the future. As sometimes I like to do is to evaluate the post-U.S., you might say the post-apocalypse landscape, the legal landscape, sometimes the political landscape. Other times we explore the economic landscape of the arrival of decentralization and the digital economy. Right now, though, is this question: what burdens do we carry living in law under the Tennessee Code annotated and in law under the U.S. Code? These are legal systems that have replaced the common law that was very, very enriching, very wealth creating up until about the 1920s was when that era ended. I have with me to ask this question Brent Allen Winters. He is an attorney and is known for his work at commonlawyer.com. He also is often can be heard around the country giving interviews on the topic of the difference between common law and statute. This is David Tulis, and Brent, thanks for joining my list for me here on the David Tulis Show. Let me ask you this: what is the burden that the listener faces or deals with living as he does now in Chattanooga under the statutes of the state and also under federal statute? Is there a way you can make him feel the effect of living in these systems? Brent Allen Winters.
Well, unfortunately, we as Americans have become more acclimated living under the burden of statutes, as the people in Russia have done for centuries, and the people in Greece and Italy and most other places in the world. And that's not a good thing. And statutes are a burden because after a while, they put a fellow in the mindset that, well, I've got to ask permission before I cut down my tree in my front yard. I've got to ask permission before I roof the little shed behind my house. I got to ask permission before if you live in California, but you're not in California, I've had people say this to me out there, before I trim my palm tree. I got to ask permission because statutes, by definition, are attempts of government to command the future behavior of men. And then under that kind of a tradition, that kind of a system called the law of the city, the Roman law, the Babylonian law, men are not free to do what they want to do. For example, just talked to a fellow within the last 2 years. A lot of old barns going down these days. Those old barns that were built from about 1900 to 1960, they're falling down, and people are trying to get rid of them because they can't keep them up, and they cost too much to paint them anymore. And this fellow had a barn that was almost down. He went ahead and knocked it down, and then he piled it up and got ready to burn it. Well, a neighbor down the road who was acclimated to the law of the city called the federal EPA. Now, the federal EPA, this is a state matter, the federal EPA had no jurisdiction to tell this man what to do with his barn. But they went in and said, we're going to fine you $10,000 if you try to burn that barn. Well, he went ahead and had it hauled off, and it cost him $10,000 for near before it was all over. But we're cowed. We're being cowed by intimidation. OSHA, same thing. Federal burden coming into the state of Tennessee or any other state and intimidating business people into believing they must comply. And in fact, as a matter of law, it's not always true, but in fact, they'll say, we'll make it hard on you if you don't, even though we know we have no jurisdiction in your particular situation to put these regulatory burdens on you. But at common law, we don't seek permission to act. We act if government hasn't spoken in a common law country, a common law jurisdiction, a common law state, such as Tennessee still is. Men don't ask to do something. If the government doesn't say anything, they're free to do it. That's not true in the rest of the world. I was down not long ago across the border in Mexico, and I was amazed at what I saw. Little tiny town across the border. I could see the vastness of the landscape around the town, but all the people were piled up in the town so tight they could hardly move and live in, well, living like animals ought to live. And I found out from people down there that everything you do there, they're confined to the city limits. They can't go out and take up land and buy land anywhere else. And they must seek permission for every little move they make. And that explains why. Of course, places like that, we call them third world countries. They don't have the freedom that you do in a common law tradition, a mindset. I'm going to do what I think's right, and I'm responsible to decide what's right, and the state legislature has no jurisdiction over me to do that. Add one other thing, if I may, David. I read a study, well, it's been now 5 years, time flies. This was done by former Supreme Court Justice. After time, he got worried and about the federalization of criminal law. And what he meant by that is the general government in Washington, D.C. is taking over the business of criminal law in the states, taking it over from the states, and they're doing it by statutes. Our Constitution of the United States grants all the authority that may be granted to the general government in Washington, D.C. If it's not in there, they don't have authority. And there are only 4 kinds of crimes that the Constitution of the United States even mentions. Treason against the United States, and by the way, that's different than treason against the state of Tennessee or the state of South Carolina or the state of Kentucky. That's 2 different things, 2 different sovereignties. But treason against the United States, the Constitution gives government power over. Piracy and felonies committed on the high seas, that's the second thing. Counterfeiting the current coin and securities of the United States, that's the third. And then 4th, violations of international law. Those are the only 4 areas of criminal jurisdiction the federal government could ever claim to have. But right now, and this is the study I'd read, and there are over 5,500 federal statutes that are criminal statutes. In other words, you break them and you've committed a crime. 5,500, and the study said we're not sure if that number's right because there's so much overlap with so many of them. When I was growing up, and I used to hear about, I know when I was a little boy, we hear about people going to Leavenworth if they got convicted of a crime on the federal level, or going to Alcatraz. There weren't that many federal prisons, and there were no federal prisons until Alcatraz. If people committed federal crimes, they were sent to Army barracks or Navy yards to go to the military prisons, because only those 4 areas up until before World War I were the only crimes the federal government ever tried. They had no jurisdiction within the states over things like alcohol and drugs until, of course, then Prohibition came along. That was all an effort to federalize, to centralize control. And if it doesn't stop, and it's going to hurt us even worse. It's hurting us now because federal prisons are growing exponentially. Over 250,000 people are now in federal prisons. The United States, and every state. We jail more people in the United States per capita than any country on the faces of our earth, including communist China. That's how out of hand criminal law, not only on the federal level, that's bad enough. The states are doing the same thing. They're multiplying statutes, and it's putting a burden on us. Every American, it is estimated by people in the criminal law.
Well, let me ask you a specific. This is David Tulis.
3 felonies a day, Dave.
Right. He's referring to Alan Dershowitz's book, 3 Felonies a Day, one that I urge my listener to read as carefully as I did. We're talking with Brent Allen Winters. His work is you can find some quotes from him at Nooganomics.com this morning, making very important distinctions between common law and statutory law. So let me just see if I can let's paint a picture. Brent, we're in radio. Radio works when the listener can see what we're talking about. Let's say that the listener has had a car accident in a common law jurisdiction where you don't have where you have a lot of people who are traveling not under commerce, not under transportation, but they're just traveling freely. In other words, they're not subject to regulation. What would a car accident look like? Would it be different than what we have now? Now everybody seems to be in transportation under the compulsory insurance statute and the compulsory registration statute for their cars as state controlled vehicles. So we have that in contrast. What would a common law car accident look like, Brent?
Well, we wouldn't have to look that far because you and I both have known people or know people that lived at a time when driver's license may have been around, but they weren't that important. And we've both lived at time when insurance wasn't mandatory throughout the United States like it is, I think, about everywhere now. But I think the way it would be handled is the way it was handled recently when I got a little fender bender in another state. And it was a kind of a freewheeling state, in a freewheeling area. And it was an unfortunate situation, but there was harm done, but not a lot. And the fellow stopped behind me, and we both got out, and we looked at our vehicles, and he said, you know, there isn't that much damage done. I don't want to fiddle around with all this legal mumbo-jumbo. He said, are you willing to talk about how we can make this square? And I said, yeah, I'm willing to talk about it. And we did, and we made it square. We didn't contact the government. We didn't need to. We took care of our own business. Now, of course, that doesn't address what would happen if somebody is mortally injured, killed, or maimed in a car accident. That's another problem. But in those cases where the government's not involved, and where the government's not involved in a common law jurisdiction where taxes are not oppressive, where there is no income tax, because in a common law jurisdiction that's inconsistent, people would have money. They would have money to deal with their neighbor. And if their neighbor didn't like the way they deal with them in a common law jurisdiction, you go to court. That's what courts are for. You don't depend upon the state legislature. You don't call the government when you have a car accident. You can't agree. You go to court, and the judge decides or the jury, I should say, if it's a jury trial, would decide what should be done. That's the way it would work in a common law jurisdiction. That's the way it has worked in the past in our own country.
So in Chattanooga, you wouldn't have, if we were living in a common law state, genuinely common law in the post U.S. era that we're thinking about, you would have much less intervention. You would have fewer people resorting to government to solve their problems. They would not go to a government agent or actor or venue for resolution. They would do it privately. And in a common law setting also, you wouldn't really have law enforcement as we have now. Why in a common law? Say something about that law enforcement in a common law world. Where would it actually operate?
Well, law enforcement in a common law world, number one, law enforcement wouldn't carry weapons. And law enforcement did not carry weapons in our own country to any degree, to any visible degree, until at least the 1840s. And the reason they didn't was because people wouldn't stand for it. And that was the tradition that they had inherited from their British ancestors. And in Britain yet today, the vestige of that are the bobbies in London. And they're famous. I even knew this as a child. Everybody knew the bobbies didn't carry guns. That bobby, that's an old name for the cops.
Robert Peel.
Because at common law, that's a vestige of their common law tradition. At common law, men didn't carry guns. Or not men, police officers, constables in the little towns didn't carry guns. But men carried guns. As a matter of fact, in England, and as Granville Sharp points out, concerning what we call today our Second Amendment, Granville Sharp was an Englishman, and he was talking about the English Bill of Rights. That was a couple of centuries ago, but he said this after he studied the subject. He said, in England, it's always been required at common law that not only must men be armed, but men must be expert at arms. In other words, the common law required that every man be armed because he may get called to armed defense of his country. That's what we call today the militia of the several states, as our Constitution puts it. So the people in such a common law jurisdiction are armed, and they have a duty to be armed at their own expense, and they have a duty to train themselves. And by the way, that's an important element to that, because if the government provides the weapons, as they do in Sweden, and the training, as they do in Sweden, well, that's okay, but that's not a common law feature. At common law, every man must be responsible. That way the weapon belongs to him. And if you accept anything from government, they'll claim they have a control of you to whatever degree they think they want to express it. And that's why in a common law jurisdiction, policemen are armed. I've read articles today from men that study the subject that say, is it time? They ask the rhetorical question, is it time that policemen are disarmed? And if policemen are disarmed, then it's going to happen. Men are going to arm themselves, and they're going to do it more than they're doing it today. And men in America do it more than anyone everywhere in the world, and women too, of course. So that would be the difference in law enforcement. That the thing about law enforcement that caused policemen to be armed in America, or the excuse for it was the burgeoning of the cities, especially New York City, Philadelphia. And they said, oh, we've got to do this. These immigrants coming in here, and it was true, I suppose, to some degree. The immigrants didn't have a common law mindset. They were from places where they were comfortable with the law of the city, the canon law of Rome, for instance, or just the civil law, the Code of Justinian, which fundamentally are the same things. But if a person, of course, and I think we mentioned this last time we talked, David, if a person is comfortable in his heart of hearts in his religious institutions with a dictator, as Romanism, for instance, does, then he will be comfortable in his heart of hearts with a government that does that. That's why Mexico and South America are the way they are.
In a common law society, Brent Allen Winters, attorney at commonlaw.org, the citizen is esteemed. He's held up grandly. He's viewed with respect and kind of reverence. Nowadays, though, the citizen is held in very low regard, and which accounts for extrajudicial, statutorily accepted summary executions by officers of citizens. We've had a couple years ago, we had a man named Javario Eagle slain in East Ridge, Tennessee. I think it was last year. There was a plumber shot down point blank by an officer. It was clearly an execution, but it was sanctioned by the Sheriff Jim Hammond in Hamilton County and the District Attorney Neil Pinkston. In a common law society, that would simply be unheard of. You would never have the raising of a weapon against a citizen, even a citizen who's armed with a knife, let's say, maybe posing a threat to himself or maybe posing a threat to others. There would be a real effort to save that man's life, not to injure him.
Oh, yes. And to show you that's true, and you're citing, and I had a client that was gunned down 2 years ago now, and it shocked my conscience, as I say. What do you say? And for nothing, gunned down for nothing. But how our mindset has changed from now, or 100 years ago. Justice of the Supreme Court, Stephen Field, sitting as Supreme Court justices sometimes do. They travel back to their home areas and sit as a district judge just to keep their hands and minds and down at the level of the people. And he was set as a district judge traveling by train north, stopped in Fresno, California. He was from Connecticut. He had gone to California and ended up living there during the gold rush. But he ended up in Fresno. He was on the train, got out, as people used to do. When they get off the train, they'd get out, and there'd be a restaurant close by, and go inside and get something to eat. And he went inside, and someone who he had ruled against, it just happened to be the former Chief Justice of the California Supreme Court, a man almost 6.5 feet tall from Texas. He came in, knew the justice would be there, and he was armed. And he had his wife with him, who was armed. And they made threats of killing him and made moves to kill him. And the marshal that was with the Chief Justice, or the Supreme Court Justice, pulled out a pistol at the last minute and killed the assailant. Well, at that time, the district attorney of that county had the U.S. Marshal arrested and jailed. And he said, I don't know what happened. I don't know if it was a justifiable homicide, but we're going to find out. That's the difference. Today, I just have a feeling that probably wouldn't happen. And when police officers murder people and law enforcement murder people, whether U.S. Marshals, as happened up in Ruby Ridge, as it came to be called, up in Idaho, those kind of places, it seems like that people aren't as quick to put them on trial, but they're quick to put, as you say, the citizen on trial. And I think it's important, too, David, that we notice that the words that we use to describe people change the mindset over time. Our first fathers didn't use the word citizen. It has crept into even our Constitution. They use the word freeman, but they believe the word citizen smacked of the law of the city. As a matter of fact, citizen is from the law of the city. It's from the Greek city-states and the Greco-Roman city-states, and it means you've been initiated into the religion, law, and government of the city. You are no longer a barbarian. That's what it meant. Anybody outside the city, the farmers that lived out on the hinterlands and herded cattle and farmed, they were called barbarians, not because they were any stupider or less educated, because often they weren't, but because they weren't part of the secret society.
Right, and the word pagan, the word. This is David Tulis. We're talking with Brent Allen Winters, and the word pagan, Brent, comes from the word païen, which is countryman. It doesn't mean necessarily that you're a lost soul, but it did, of course, in the Middle Ages refer to people who were lost from God because they didn't hear the gospel. They were called pagans because they were païens. They were country people. This is David Tulis. We're talking with attorney Brent Allen Winters at commonlawyer.com. He is giving us a sketch of life in Chattanooga, what it might be like if we did not live under our current regime of statutes, whether Tennessee Code, annotated, or the federal code. We're going to talk a bit more about the common law concept, life at liberty, the dangerous life, the risky life of being free. It's very difficult to imagine, but we're going to think about it in just a minute. But now, some important messages. Stand by.
The Tennessee Valley's news talk leader,
Nooga
Radio,
right?
digital.